All right. Next case on the docket is Moore versus Moore. Okay, appellant may proceed when they're ready. All right.
Good morning. May it please the court. I'm Bill Gressley from Jacksonville. On behalf of the appellant, Michael Moore. With me at counsel table is my appellate co-counsel and trial counsel for Mr. Moore, Carol Caldwell from St. Augustine. Excuse me. I usually have a somewhat strong voice. I spent the evening here last night, and I guess I've discovered that I'm allergic to motorcycles.
That's okay.
Having issues this morning. This case has several distinct issues, and a couple of them are very confusing. The one that I want to talk about at the very end is the issue about the house, that we had some extraordinary proceedings.
And
here.
That's been clarified, correct?
Not from my perspective, Your Honor, and if you want, I'll start with that one.
Yeah, if you would.
Okay. The paragraph 3 and paragraph 5 of the final judgment contain two different provisions relating to the former marital home. The context for the problem here is that during the course of these proceedings, there was no temporary support and needs order entered in this case. It was done by agreement of the parties, voluntary agreement, and there was no controversy, no conflict about what the deal was. My client paid for everything. He continued to pay all the mortgage payments, all the utilities, homeowners association, lawn service, whatever there was. He also paid all of the former wife's credit cards, and the one step back, the parties historically lived off of their credit cards. The husband's salary, my client's salary, was a commission-based salary, and he's a 12.5% owner of a privately held corporation.
The judge entered a post-judgment order.
Yes.
On your motion.
Well, he did a couple of things. The point of all of this is that the parties continued to support themselves with credit cards and 401k withdrawals during the pendency of the case. And the final judgment provided that if the husband gave the wife 30 days notice to vacate the marital home based upon his representation, he would pay all the bills, that she was to vacate the home. And then paragraph 5 has this, what I call convoluted, ambiguous statement about the fact that if he chooses not to, then the wife can list the home and he can be an opt-in. I think that meant a right of first refusal. Right after the final judgment was entered, you got to understand, my client's paying for two different residences now, and he's got declining income. Right after the final judgment was entered, he sends her a letter through counsel that says, this is my right under paragraph 3 of the final judgment. I want you to vacate the home within 30 days, and I will pay all the expenses. She refused to move. Ms. Caldwell filed a motion to enforce that. We have a hearing, and the judge says this is not ambiguous. He was supposed to pay her off for her share of the equity in the home, and then he could move in, which is not what the final judgment says. Neither paragraph 3 or paragraph 5 says that. It could be interpreted that way. It could also be interpreted several other different ways, which is, by definition, an ambiguity. So the judge says that he wants his cake and could eat it too, because at the time of the final judgment was entered, he had the money to pay her off. That's without factual support. There's no evidence of that. Matter of fact, the evidence was he was continuing to get and increasing the indebtedness of the parties. They're living the marital lifestyle on decreasing income and financing it by deficit spending. Opposing counsel moved to supplement the record with this order. And this is 7 months after the final judgment order, and then claims that it's now moot. Well, in her brief, she admitted it was ambiguous. Her trial counsel at this hearing admitted it was ambiguous. And all of a sudden, they get this order from Judge Alexander that says, no, that's not what I meant. It's not ambiguous. And so, to my surprise, this court allowed the record to be supplemented with this order. And this is the first time in 25 years of doing appellate practice I've ever seen this. So that's the confusing part, is I'm not sure where that leaves us. That issue has never been briefed. It really was not capable of being briefed, other than if you order today that we do supplemental briefs, because the briefs had already been filed when this was decided by the judge. To complicate it even further, which I really don't want to do, but this is where we are, the house is sold. The final judgment says that the former wife's obligation for the credit card payments can be taken from her sale proceeds, and that didn't happen. So we've got ongoing issues about the house. And my client continued to pay the $4,000 a month in what the trial court said was temporary alimony, that he was reserving jurisdiction over that issue for a minimum of 6 months to revisit once the house is sold. That's another, what does that mean? He's going to reserve jurisdiction for at least 6 months. Okay, so we've got a $4,000 a month alimony payment. We've got $22,000 worth of monthly expenses that my client has been continuing to pay throughout these proceedings, and his income is not even close to that. So the issue about the house gets more complicated because of items that are going to need to be dealt with on remand. We totally disagree with the judge's interpretation of his own order that everybody admitted until they got one they liked was ambiguous. And I've asked the court to send it back to consider this.
I guess maybe, from what I understand, there have been subsequent orders entered, post-final judgment orders that may be problematic.
Just one. And that's the one that the court allowed to be supplemented in this record, that the trial judge, when everybody agreed it was an ambiguous final judgment on this provision, he said it's not ambiguous.
But I mean, if he entered an order which he believed clarified it and the house has now been sold, then I have a hard time understanding why we need to remand based on the issue that's raised in point 3, which is that the provisions relating to the sale of the house were ambiguous, because it was really my client's ability to obtain possession and not have to pay for a separate residence. And that's not an issue any longer.
It's an issue only because the trial judge, in my humble opinion, in excess of his jurisdiction, because he amended the final judgment. But I mean, the request, the argument on issue 3 was that these provisions regarding sale of the house are ambiguous. Well, it wasn't just the sale. It was my client's ability to take possession, and now he's
okay. But then those aren't issues any longer.
No, but his right to obtain credit for all those payments is an issue.
But that's a different issue. That's not the issue raised in issue 3.
Again, because the judge entered an order that allowed this to happen without his jurisdiction being present. But you're right, that specific issue has been resolved by events that I'm not sure how it happened, but it did.
Okay.
The real issues here are, number one, the income, definition of income. This is crucial because, as I stated a second ago, and I apologize, I want to save 3 minutes for rebuttal, and I apologize that I didn't say that up front. So I assume that that's 3 minutes off of the time clock here is when I need to stop.
You're well ahead of yourself, so you've got 12 minutes left, so the clock will tell you when you got to 3.
Thank you, and I will run out of time. I'm very familiar with this. The issue 1 is the ambiguity in the final judgment as to what is the husband's income. Everyone understood, and the experts so verified, that my client gets commission-based salary, and then once a year as a minority owner of a privately held corporation, he gets a distribution. Right. Well, the final judgment says, and this is on page 4, it's paragraph E, his income is going to be the same for 2010. He expects to receive an income distribution from his company similar to what he received in the past several years, approximately $54,000, plus stockholder dividend checks of between $50,000 to $75,000. Dividends and distributions were used interchangeably in this case by the experts. I think, because it's a sub-S corporation, I think it's actually a distribution. But I'm not a tax lawyer. It's not relevant. What's relevant is this is ambiguous. It appears that the judge may believe that my client is making dividends and distributions.
It looks to me like there's nothing else in anything that the judge said or anything in the final judgment that indicates anything other than he was using those terms interchangeably, so it's a dividend or distribution. Because if you look at the numbers and where we ended up with alimony and that kind of thing, it certainly looks like it's based on the commission-based salary plus whatever that is at the end of the year. I'll call it a dividend. But
And I would submit, Your Honor, that is speculative. That's the answer brief's response to this as well. He would have ordered more alimony.
Seems to be right.
I'm sorry?
The math seems to be right. In other words, that seems to be a scrivener's error. I think the judge understood he just got a dividend or a distribution.
If so,
one time at the end of the year.
and if so, then the question is, what is the equitable distribution and the alimony amount neither one of those are correct. The $4,000 a month was supposed to be a temporary award, and now we've got this final judgment that says, well, I'm going to reserve jurisdiction over that, and we're going to revisit that. The former wife admitted at trial that her only testimony about her need was the $13,000 some odd a month in her financial affidavit, which she made at the beginning of the case, recognized it was based on the deficit spending that had allowed them to live this lifestyle, and that the husband's income was down by 50%. And so we've got a situation here where
her expert testified that if you pegged alimony at $3,800 a month, that would pretty much even up the income based on commission only, correct?
I'm not sure that it was based on commission only, Judge. I think that both experts testified as to his total income because he gets attributed to him 100% of that 12.5% of the profit as his distribution. They only pay 80%, which is enough for him to pay the tax liability on that, but they retained some of the earnings. I did not take from this that I thought the experts were both within $1,000 of each other on the income level, and I think they both used the total amount of income. The important part from my perspective in terms of what I believe to be errors that need correction by this court is that when my client paid throughout this case, and let me back up one step, the expert's testimony was at a time when they were assuming that there was going to be a truly equal distribution of assets and liabilities, and that didn't happen. And that's what I really need.
Well, there was an equal distribution of assets, and then he got more of the liabilities, correct? He got $20-something thousand more.
The judge refused to, at the beginning of trial, the party stipulated that there was $63,000 in the 401k that was non-marital. And he refused to give that to my client. He essentially distributed a non-marital asset.
Well, he said your client spent it, is what he said.
He did.
That's what he said.
Where I'm getting ready to...
He said the money he took out and spent was the non-marital money.
And that's...
Can't the judge do that?
If there's evidence to support it, and there's not here. Absolutely, the judge can do it. If there's evidence, the case law is clear.
How is entertaining young women, female friends, whether you call them paramours or not, how is that a marital expense? I'm having a hard time with that argument.
What it is a characterization by trial counsel that all of this money that he spent eating out was on young women and in bars.
He
the
spent
truth is...
an amazing amount of money eating out. He wouldn't tell anybody who were clients and who were not, and I understand the reason for that, but I mean, if you're going to take that position, I'm not going to tell you who the clients are, and he did admit that a lot of them were young female friends. So, I mean, why isn't that enough for the judge to say?
Well, let's put this in context. I disagree with him saying that. What he said was, you look at my tax returns, every year I spend what I consider a lot of money eating out. The family ate out 80% of their meals. All of these random credit card statements that are thrown into this table in the answer brief are just that. They're just random statements. We don't know how much of that is the appellees, how much of that is the appellants. Whether or not the appellant rightfully claims these as business deductions is not an issue. What's at issue is that it was historical fact that he expended significant sums of money entertaining anyone who might be able to bring him business. His business is a satellite office of a Raleigh, North Carolina-based trucking company, and all of the other, the one in Maine, one in Tallahassee, and two in Texas, were shut down. He was terrified at 64 years old to have his company believe that he wasn't profitable. So he was not submitting those expenses for reimbursement to the company, and he hadn't done it for several years for the sole reason of not wanting to rock the boat. The same reason he continued to pay $20-something thousand a month in expenses for the parties, including for the college son, who the parties agreed they were going to make sure he got paid for, and which of course now has become a claim in the answer brief. Well, the judge discounted that because it was improper. No, it was not improper. It was based on the parties' agreement. This thing about paramours or even entertaining, he did that throughout his marriage. He did that as part of his business, and it wasn't just young females. There were some times that he had multiple young women, and sometimes he had older women, and sometimes he had truckers from who knows where. I mean, there was no evidentiary corollary between these expenditures and a, quote, depletion of marital assets. The only real evidence we have is that he spent $185.
I mean, if he spends thousands of dollars a month entertaining and admits that some of them were not clients and some of them were young female friends.
Which he didn't admit that.
Well, I'll have to look back in the record, but
Please.
I thought that he did.
Please.
Okay.
I mean, and if I'm telling you wrong, then shoot me. I've read this multiple times, and all of that inference is from trial counsel pulling out a receipt from, the sandbar or wherever he liked to frequent and say, okay, on, March 13th of last year, who were you with for this?
Well, I mean, I guess you would admit that the woman that the former wife found him with at the bar wasn't a client, the one that he gave gifts to and professed love to.
3 years before the filing.
Right. I mean, so there's evidence to indicate that there's something other than a business expense there, and he would not disclose who clients were and give any information from which the trial judge could call out and determine, okay, these are legitimate business expenses. I mean, I think that gives the trial judge a lot of latitude.
I think we're putting the cart before the horse here, Your Honor. There's a couple of things that you need to keep in mind when you look at this. One is that there was an injunction entered by one of these establishments against the former wife early in the case to keep her from stalking people and calling up and accusing people of things. There was no evidence of anything other than my client liked to go out and eat and have drinks with anybody that was even remotely related to a business. The whole thing about, quote, paramours, counsel's questions. There was nothing of any evidentiary value other than the inference that and the former wife's testimony that she did not appreciate these expenditures. Well, the case that I found the most fascinating and perhaps most helpful here is out of the third, and I don't want to botch the name, Guobaitis, Guobatis. This is the doctor who had an ongoing drug and alcohol problem throughout the marriage and expended large sums of money to finance that. And at one point, the wife said, you've got to go get help. We're not going to pay for an expensive place. We're going to pay for a self-help program. You do that and we'll stay together. He eventually fell off the wagon. They eventually got divorced, and the trial judge tried to do what the trial judge did here, which is say, oh, well, you've dissipated all these assets, so you have to be responsible for the lion's share of the marital debt, and you get 20% of the assets. There is no question in this record that the 401k expenditures, which the judge said violated the standing family law order, all went to keep these parties moving and functioning during the course of these proceedings. Those are marital expenses. The case law is clear that unless you have a very, very clear factual connection between expenditures and dissipation of marital assets, that it's improper as a matter of law to unequally distribute the assets and liabilities. I'm into my rebuttal time, and I'll rest it.
May it please the Court, I'm Catherine Swain. I'm here on behalf of the appellee Sherry Moore. I will go in the order that my opposing counsel did. With regard to the third point, that is a new issue also. The appellant did not raise for this Court's determination as issue of credits. The final judgment was silent as to credits with respect to the marital residence. If he had wished to appeal that, then he should have appealed that in this brief. He did not do so, so he should not be able to come back on that particular issue. With respect to the alimony, The 2010 income finding was there was $156,000. That was a consistent number utilized by the husband's expert witness as well as the wife's expert witness. The trial judge questioned both of the, excuse me, I think my frog got, from him. Yeah, motorcycles. But it appears that the trial judge did understand how much income was available to the husband. When you looked at the actual determination of net income by the husband's own expert, he says that the husband had net income of $5,600, but the husband agreed with the trial judge that, yeah, I think that you can award $2,500 to $3,000 of alimony to the wife. So at one point of the trial, the judge said to the parties, are we here basically on a $1,000 difference in alimony, a $3,000 versus a $4,000 alimony claim? And the trial counsel for the husband said, yes, that's what we're here for. So the trial judge did look at the evidence before. If you look at what happened, there was a house mortgage of $2,500. There were property taxes related to the marital residence of over $400 a month, insurance of $253, homeowner associations due with respect to the marital residence, as well as a line of credit. And the wife also had a car loan that they passed over to her of $1,100. So those expenses really consumed a lot of what the wife was getting as an alimony award, and you have to look at need and ability to pay. The court did impute income to the wife, but it was at minimum wage. So there was a Scrivener's error, it appears, because it was a little confusing as to whether it was a stock distribution or whether it was a dividend, but it was clear that based on the record, the $4,000 alimony was a fair and equitable alimony award, and that there's no abuse by the trial judge in its discretion in awarding that amount. The issue pertaining to the 401k, there was no agreement that the husband would get $63,000 free of any surcharge. Here the husband had a non-marital asset. It was the 401k share. He went in there and he pulled, without the wife's knowledge, over $125,000 or approximately that amount. She finds out about it at a deposition. On her financial affidavit, she doesn't show the adult son's college expenses. The husband does show the adult son's college educations, and the court talked about that. It said, basically you've painted me in a corner with regard to paying these college expenses for a child that's over the age of minority, and I don't know what to do with that, in essence. So what happened was, here's the husband that didn't get the court's written order authorizing the disbursements from the 401k. He didn't get the wife's written consent per the family law order to take those withdrawals. So how can we say we have an agreement with regard to the child's college expenses? And those expenses were running $5,000 a month, and the son, like the father, was out there blowing money. He was allowing his son to incur entertainment expenses of around $1,700 per month. And the wife testified, I had no knowledge that he had unfettered use of that credit card. So she finds out from the husband he's over there giving this money out to the son. With respect to the business expenses, one of the questions the trial judge said, it wasn't a question, but he basically told the husband, look, if you're not going to go back and seek business reimbursement expenses, and you're saying they're business, then what am I to do if you're not going to even go back to your employer and ask for that? The husband testified that he wasn't going to seek reimbursement now. He said, until this divorce is over, I don't want to do anything. So the question is he going to be able to come back in and seek reimbursement? The wife testified that he typically got business reimbursement expenses from the employer, and he cashed those. So they would not have had a record of the monies being deposited in there in the event that he did take those monies from the employer. The business expenses were also significantly high in relation to what income they produced to the husband. If you looked at the tax returns, his income consisted of about $90,000 in 2009. In relation, his unreimbursed expenses were 60% of that. So that doesn't produce income for the marital estate. He was utilizing those monies to take care of this woman, Melissa, who he was sending gifts to. He was going out and spending money and texting women about come over and I'll take care. They were talking about having him pay for food. He was going to this one particular bar that there was no injunction. It was actually a trespass warrant that was issued against the wife, where he spent over $3,000. And one time period per the wife, and also $17,000 prior to the date of filing, based upon her review of the records. In addition to that, he had not sought reimbursement for his business expenses in 2010. So if the business expenses in 2009 were $51,000 and he didn't seek reimbursement after he filed in 2010, and then he incurred an additional amount, then there is in excess of the amount he took from the 401k. Also, when he took the 401k, he incurred income taxes, and the court had testimony before it that what the parties typically did was they would charge, and they would wait till they got the stock distribution and then pay the credit card debt. He jumped the gun. He didn't wait till he got the stock distribution or dividend distribution in 2010 to pay those expenses. He instead started pulling the money out of the 401k. So he had ability to hold off and do what the typical experience of the parties in the past were, to pay them when the money came in from the distributions from the corporation. With respect to the payment of those funds, I cited to the case of Beers, as well as a Romano case with regard to the depletion of the marital resources. This particular case, it reflected that he used marital funds for his own benefit for a purpose unrelated to the marriage at a time when the marriage was undergoing a breakdown. My opposing counsel cited to cases saying, look, it's okay if you take from the marital assets if you're using it to pay reasonable living expenses. These payments, he was running over $2,700 per month in eating out expenses, were not reasonable living expenses. He was using these for his fun, and the wife said, why should I be responsible to pay his bar tabs? I mean, it's not my responsibility to do that. With regard to the assets, he also took the income tax refund of the parties, and the court recognized that. So he not only took the monies from the 401k, but he also took the income tax refunds and utilized those to pay expenses. And despite that, they still had credit cards that increased. The credit cards at date of filing were one amount, and by the time of trial, he had increased them by $25,000 approximately. So it didn't reduce the credit card debt. The trial court said, because of your unauthorized withdrawals from the 401k per the standing family law order, also your use of these funds to pay for other women, and your payment with regard to the college expenses, we're not going to let you get your non-marital share of $63,000 to put to the side. But you unilaterally made that decision, and he subsumed that money. So we would ask that the trial court's findings and the disposition be affirmed. Thank you.
Thank you.
Briefly, Your Honors. Excuse me. When counsel points out the colloquy between the court and counsel at a trial about, are we really here on a $1,000 difference, Ms. Caldwell said yes, and Ms. Shine, trial counsel for the wife, says, no, we're here because of the annual distribution. So it's not that this was just about $1,000. It was about the attempt to increase the amount of alimony beyond where we were. The only reason that I raised this issue about credit for the house is because of the convoluted way in which the provisions about the house were contained in the final judgment, and the fact that we had events post-judgment that sort of subsume that. It's a non-issue here at this moment. Hopefully we won't have to be back to talk about it down the road, but it's possible. The real financial reality here is that all of this litany of bad behavior that you've just heard from Applebee's counsel, and the extraordinary expenses for the son's college education, all have not come from that testimony. It's come from the advocacy of counsel. The former wife knew about the 401k distributions during months and months before trial. She knew that all of her bills were being paid, that she got $1,000 a month put in her bank, and she got $2,000 a month paid on her credit cards for her to spend. She admitted at trial that she realized that they did not have the money for her to live like this anymore, either one of them. And the reason my client couldn't wait until the annual distribution to pay off the credit cards is because he was running up the credit cards and needed the extra money to pay 2 households instead of 1. My client is at an age where he's not incurring a penalty for the 401k distributions. He's paying taxes on it as if it was ordinary income. This idea about gifts to women and text messages, there was one gift several years before the marriage broke down, and there was some text messages having to do with, where were we going to have dinner, or can I borrow some money? None of that translates into a dissipation of marital assets. If you look at Schedule A to every one of the parties' tax returns for years, all of the ones that are in evidence, you will see extraordinary expenditures for business expenses. The former wife got a benefit from those because they reduced their income tax liability. That's not a basis to say, well, you have to now pay more of the debt and you get less of the assets because we disapprove of how you spent them. That was the way the parties lived. And I would like to leave with the fact that the standing family law order specifically allows expenditures without court order, without written agreement, except in the usual course of business or for customary and usual household expenses or for reasonable attorney's fees in connection with the action. All of these expenses were typical historical expenses, including the payment of the college son's expenses.
You've gone over your time.
Thank you very much, Your Honor.
And just so you know, and I'll look back at it, the reference I was making earlier was to pages 303 and 304 of the record, the husband's testimony.
Okay. Thank you, Your Honors.
Okay, last and final case.